Okay, welcome to Palestine, Israel, and International Law, the long view, and since October 2023. I'm Omar Shehabi. I am the moderator for this event, and it's a great panel, and I feel very privileged to be here. Who would like to begin? Do we have an order?
We do have
Okay.
Sure.
So, Rabea Eghbariah is a doctoral student at Harvard Law School and the author of Towards a Legal Concept of Nakba, which was ultimately published and is available in the Columbia Law Review. To turn it over to you.
Thank you. We were strictly limited, so I'm going to actually time myself to not other stuff. I'm going to start by telling us a story about 1983 and 1982, about the Sabra and Shatila massacres. And from there, we'll probably move on to tell us a little bit more about a frame we should probably think of about how to understand this long view of the Palestinian condition. So in February 1983, I'm reading from the Not Censored Anymore piece. In February 1983, an Israeli Commission of Inquiry found that Ariel Sharon, then Israeli Minister of Defense, bore, quote, personal responsibility, unquote, for failing to prevent the atrocious massacres committed in Lebanon's Sabra and Shatila refugee camps in September 82. The Commission further found that other senior Israeli officials, including the Israeli Prime Minister Menachem Begin, were also, quote, indirectly responsible, end quote, for the massacres. The report noted that Sharon's office issued instructions asserting that, quote, for the operation in the refugee camps, the phalangists should be sent in, end of quote. That night, the Lebanese militias were allowed into the refugee camps to conduct the massacres as the Israeli military fired flares to eliminate their visions. As was later revealed, Morris Draper, the American envoy to the Middle East, told Sharon, or Sharon declared before him, quote, if you don't want the Lebanese to kill them, we will kill them. Murdered over 1,300 men. 3 decades later, the Israeli archives would reveal that Sharon had feared being accused or held liable for genocide. That same month, another important, yet much less discussed report concerning Israeli conduct in Lebanon was published. The almost 300-page report was the product of an unofficial initiative of 6 esteemed jurists headed by Sean McBride. The commission was constituted in August 82, before the Sabra and Shatila massacres, to review the legality of the Israeli invasion and conduct in Lebanon. By the time both commissions published their report, the UN General Assembly had adopted a resolution strongly condemning Israeli action, declaring the Sabra and Shatila massacres as, quote, act of genocide, end of quote, and calling to suspend economic, financial, and technological assistance to and cooperation with Israel. Notably, actually, the resolution included a clause deploring the United States veto cast in favor of Israel earlier that year to prevent the implementation of Security Council decision that declared the Israeli annexation of the occupied Syrian Golan Heights null and void. The Commission issued its report and examined the applicability of genocide to Israeli actions in Sabra and Shatila. The Commission members were split about the standard of intent required for the crime of genocide. Specifically, 2 members of the Commission concluded that genocide, quote, requires a special intent. While the Commission refrained from issuing conclusive recommendations about genocide, it still included an illuminating majority note on genocide and ethnocide in its appendices, where it expanded on the Commission's majority opinion pertaining to the question of genocide and its applicability in the Sabra and Shatila massacres. The Commission says, and I'm just going to wrap up by saying, by quoting from it, The massacres that took place in Sabra al-Shatila in September 82 can be described as genocidal massacres. And the term complicity in genocide is wide enough to establish the responsibility of Israel for these acts. But the denial of nationality to Palestinians has resulted in all Palestinian social institutions being considered to be part of the apparatus of the so-called terrorists of the PLO. The borderline between Mr. Begin's claim to, quote, eliminate the PLO and the total destruction of the social organization of the Palestinian people in Lebanon is a very narrow one. And the constant reference to the need to purify the territory of Lebanon of the PLO elements has been conducive to attacks on the autonomy of the Palestinian people. End of quote. So the Commission states that there is evidence to show, it proceeds to state that there is evidence to show that the treatment of Palestinians in those areas, namely in Lebanon, was related to, quote, Israeli policies in the West Bank. Taken together, these policies through their disposal, their sentence would be weakened, if not destroyed. Now, contemplating the applicability of the Genocide Convention to Israeli policies regarding the Palestinian people, the Commission struggles with applying the concept of genocide and resorts to saying that the definition of genocide is not limited to the formula adopted by the United Nations. In 1948, the legal concept of genocide is quite consistent with identifying policies designed to destroy the identity and will of a national group, as well as the Nazi paradigm of the Holocaust. So we're seeing already the Commission, I will stop here from the article, but we're seeing already the Commission struggling to define the Palestinian condition, to fit the Palestinian condition into the genocide formula, the legal formula of genocide, and tie what's happening at that time. We're talking again in 1982 in Sabra al-Shatila with what is happening in the West Bank or elsewhere in Palestine. And so I just want to proceed by saying that our current international legal frameworks have not only failed to change the material reality of Palestinians, but they've also discursively limited our ability to identify the root causes of this reality. What we're seeing this struggle of the Commission in 1982 is basically 4 decades later, we still lack an agreed upon or a comprehensive legal framework to describe this Palestinian condition in law. International law is stuck in an outdated paradigm that takes the partition of Palestine and the brutality of the 1948 Nakba at face value. And the international community rarely questions the legal infrastructure that enabled the Nakba in the destructive process of establishing the State of Israel. As a result, legal discussions often obfuscate the totality and continuity of the Palestinian condition over time and space. We tend to discuss, for example, the genocide in Gaza in separation from the Israeli settlements in the West Bank, and the annexation of Jerusalem in separation from the Palestinian right of return. At best, we cluster some of these discussions under the umbrella concepts of illegal occupation or Israeli apartheid, but still evade crucial legal questions about partition, self-determination, or the 1948 Nakba. Too often, the application of these frameworks also contributes to exceptionalizing the treatment of 1948 Palestinian refugees, as we've seen by the ICJ Advisory Opinion, or Palestinian citizens of Israel from the overall condition of the Palestinian people. But we must understand that the illegal Israeli occupation of the 1967 territories, the unfolding genocide in Gaza, the denial of refugees' right of return, and the Israeli practices of apartheid are manifestations of a deeper structure rooted in Zionist settler colonization of Palestine. To move forward, international law must reckon with the foundational experience of Palestinian loss and call it by its name, Nakba. International law must also recognize that the Nakba never ended, but rather birthed a brutal system of Israeli domination, a Nakba regime that has practiced forcible transfer, conquest, annexation, occupation, apartheid, and genocide over different spatial and temporal intervals. Together, these crimes form a totality that is greater than the sum of its parts. Nakba is therefore the appropriate name for the crimes against humanity committed against the Palestinian people. This is, in a nutshell, my argument. It is premised on the foundational violence of mass displacement, structured by a legal system of fragmentation, and orchestrated by an overarching purpose to deny Palestinian self-determination in historic Palestine. The road to justice in Palestine is long and tumultuous, but foregrounding, theorizing, and analyzing the Nakba and international law is a place to start. Thank you.
Now, do we have questions? Break to the next.
I think that maybe we.
You want to do strength? I think let's just keep going. If you have questions,
Sure.
Discussion later.
Okay.
Yeah.
Okay. Well, let me give you a proper introduction. Gallatin Huque is a senior staff attorney at the Center for Constitutional Rights here in New York.
Thank you, and I'll also follow Rabea's lead and I myself. The Omar is a fierce timekeeper. Thanks so much for the organizers for inviting me to this conversation on international law in Palestine. Thanks for everybody that's attending virtually. I just wanted to open by acknowledging that it is, completely stunning and surreal to me to be having this conversation here in New York on international law in Palestine on this beautiful day. While I'm sure that all of us, whether it was on the subway platform this morning or prepping for our talks, have been seeing some of the worst images that we've seen all year, or over a year of this genocide on our phones. We're watching in real time every aspect of life in the north of Gaza be exterminated. We're seeing roundups of men, women, and children. And the Israeli, all of this intends that it intends to silence the remaining journalists that are left in the north of Gaza. So with all the role of international law in this moment, my introductory remarks are not in the recorded version. So yeah, we do find ourselves wondering what is left to say about international law and its role in this moment. While at the same time, I think we're all feeling urgency to figure it out and to not abandon any of the possible tools that are available to us. So Palestine is often talked about as an exception. Last year has shown the limits of this exception framework. I think that rather than functioning as a mere anomaly, something that can be set aside without issue, Palestine has become the site upon which institutions, including the law and international law, have exposed, unravel, and reconfigure it themselves. And so it's imperative for everyone to be paying attention to that process. I think all of us in practice or who observe the situation have different ways in which we can illustrate this unraveling in our different areas of work. So I'll just use my comments in my remaining time to speak to the US context. As early as October 19th, the Center for Constitutional Rights, where I work, published an analysis briefing Israel's assault and military. We, of course, focused on the US's role. And this was really early on, October 19th. I mean, at the time, we really wanted to focus on getting international mechanisms to kick in. And so we highlighted the duty to prevent, which is, of course, something that kicks in. For the most direct answer, which is it is a legally apt term, the fact that it applies to the law, lead us to that conclusion. The duty to prevent was also a key animating principle, especially in those early days. We really thought that by putting the and codifying the crime of crimes, states decided that even if you thought a genocide might be about to unfold, states have duties to do everything in their power to stop it. Of course, we all know what happened. Nothing. The US continued its unconditional support, despite not just CCRs, but plenty of other lawyers, scholars, warnings. So in November of 2023, about a month after we published that paper, we filed a lawsuit in US federal court. It was on behalf of Palestinian plaintiffs suing President Biden and other US officials for their failure in their duty to prevent and complicity in Israel's unfolding genocide. We sought and obtained a hearing on the objection of the US government. And during a 5-hour hearing, the plaintiffs powerfully and devastatingly testified to the many layers of harm that they and their families had experienced. One plaintiff even called in from Gaza, which was perhaps the first time in federal court history that a witness has testified directly from an ongoing genocide. They urged the court to order the administration to stop sending weapons and otherwise assisting Israel's assault on Gaza. And each one, after the other, referenced the Nakba in their testimony, as it was for each of them a central part of telling our story and conveying to the court the scope and the scale of the impact of Israel's actions. The judge, a senior judge, was visibly moved, and he ended this long day of hearings by saying that this was the most difficult legally and factually case that he had ever dealt with in his career. But the decision came very quickly. A few days later, although the judge reached the conclusion that the evidence was, quote, uncontroverted, and he agreed with the ICJ's conclusion that there was a plausible genocide, he cited the political question doctrine in US law as barring him from issuing any relief. And in his frankly stunning opinion, he nearly apologized for the powerlessness of the judicial system as he implored the political branches to act. So he essentially accepted the government's argument that even if they were to commit a genocide, it would be beyond the purview of the court to stop them. On appeal, a 3-judge panel agreed, and the Ninth Circuit denied our petition for en banc review. So this striking abdication of judicial responsibility is really worth interrogating. As news recently emerged that Secretary of State Blinken and multiple officials lied about Israel's blocking of delivery of food and medicine in order to keep sending weapons to Israel. As universities rewrite their speech and conduct guidelines, instructing faculty to not talk about Zionism or foreign affairs without touching on both sides, we are witnessing institutions contort or self-immolate rather than protect Palestinian life. As the Blinken example illustrates, the Biden administration is willing to sacrifice their own proclaimed values and checks and balances, as well as the international institution that they've purported to protect in service of a genocidal project. In a recent conversation with Dr. Hassan Abu Sitta, who's, I believe, still in Beirut, he recently provoked some of us in that conversation as we were talking about this conundrum. He asked us, what is it about Palestine that leads institutions, courts, and states to forsake their own interests? As this genocide continues to reshape our institutions in a fundamental and frightening way, answering this question could not be more urgent. Questioning Palestinian death tolls in Gaza has given way to not even mentioning them in Lebanon. Whether it is the precedents being set by the wanton violation of international law, the types of warfare or weaponry or death tolls being normalized, or the level of domestic repression that's being pursued on college campuses, what we are seeing is not Palestine exceptionalism. It is a forging of a new and frankly terrifying world. I will stop there.
Thank you, Dale. Next up is Dr. Karin Loevy, who is a professor at NYU and is the coordinator of the doctoral program at NYU Law School.
Thank you. Thanks. I'm not a professor at NYU.
You teach.
A new school, but I
New school,
manage the
okay.
law school.
Yes. Okay.
So my paper, I'll try to make it short, give more time to others actually. I want to hear what all of you want to say. But what I suggested to Ralph that I'd like to present at this panel of the International Law Weekend was a paper titled "Where is Gaza in International Law?" And it was about the place of Gaza in international law. And it was the research that I've been engaged in before October 7th. And I just recently came back to it, and it became a much heavier thing. But basically, I think it was my findings there were reinforced. So if one tries to characterize Gaza as a place in international law, as a territory in international law, there are two questions involved. So one is the doctrinal question, right? So what is the status of Gaza? Is it an occupied territory? Is it a sovereign state in the making? Or maybe it's an exceptional entity, a sui generis entity, right? And then there's the more general question, which is a historiographical question. Where is Gaza in the development of international law? Where is it in the discourses of international lawyers? What does Gaza mean for international law? What space does it take in the discipline? So to answer both of these questions, I think my research was trying to do, one needs to be especially attuned to voices of Palestinian, especially Gazan lawyers and activists, in how they characterize Gaza. What are the terms they use to describe its legal status? What are the histories of international law that they tell to explain its creation as an entity? What are the sources that they rely on to substantiate their claims, their legal claims? For all these questions, I found a huge gap between the way Palestinian lawyers, scholars, and activists, and also 12 lawyers more generally, say what Gaza is, what kind of territory it is, and Western and Israeli account of the same territory. Again, not so much in the bottom line doctrines, so is it occupation, is it sui generis entity, but in the terminology used to describe the territory, in the sources used to substantiate the claims, in the histories of international law that are being told. And this gap that was so huge that it sometimes feels as if these are two different disciplines, not the same field. And I was looking at a lot of international scholarly debates, but also advocacy work, so claims made about the status of Gaza in those. So I claim that this gap is not only, it's not sustainable, it's growing, and it reflects a very deep ongoing crisis in the discipline of international law, of its certain disciplines within international law. And it possibly also predicts a shift in the discipline itself. And so moving to the other part of that second question, which locates Gaza in the development of international law, this has to do with that. And here, I don't want to go into that part too much, but I'll just say that what I try to do is I try to locate Gaza in the development of the scholarly debates within international law through three shifts that I think Palestinian lawyers and activists have been involved in the last couple of decades, mostly, but I think much longer than that, actually. One is the move to empire and coloniality in the historiography of international law. Second is the move to genocide in the study of international transgression and in genocide studies, and their influence on the development of scholarship in international criminal law. And then third, the move to international law as a discipline, from a discipline, international as a discipline of crisis to international law as a discipline of everyday life. So rather than continue to I think focusing so much on the exceptions, focusing so much on the crisis, just reinforces the status quo. And we should instead focus on the structural problems of injustice in the international legal order. And this is in the 12th tradition, but it also, I think, in, for example, Noor Arafat's demand that we de-exceptionalize the Palestinian struggle, connected to other historical and ongoing struggles. So at the end, and so I'm not going to go into each one of those moves, but I want to say that at the end, we asked, where is Gaza in international law? We asked lawyers, and they say it's at the very heart. And that's these lawyers. Lawyers in Gaza, Palestinian lawyers, and always say 12 lawyers, and they say it's in the very heart of international law. So Gaza's experiences and practices, and here I'm talking about practices at local knowledge, such as the knowledge about closure, about siege, about genocide, the kind of languages Gazans use to express the experiences of everyday life in Gaza before October 7th, before the genocidal war, and today, so experiences of death, everyday death as well, not only express the crisis of legality that the global order is experiencing, but also present a new, maybe universal meaning for the discipline and an opportunity for solidarity for international lawyers and activists all over the world. So.
Next up is Ralph Wilde, who is a professor of law at University College London. And although I'm sure you're here in your personal capacity, represented the League of Arab States in the advisory proceedings.
Thank you very much. So as the co-organizer of this panel with my dear friend, Professor Atahindi, who's with us online, I want to begin by giving my great thanks to my wonderful fellow panelists for kindly giving up their time, and also to one of these panelists, Professor Karin Loevy and Professor Vasuki Nasaya, for enabling us to meet here in person at NYU, and to our friends at Law for Palestine, and in particular Ihsan Adel and Huda Abu Daga for vital logistical support and hosting the event online. As was mentioned, I had the great privilege of representing the 22 states of the League of Arab States in the advisory opinion case. And as was also suggested, I'm here very much speaking entirely in my private individual capacity, only not also as on behalf of the League and its members. I'll present on the fundamental matter of the illegality of the occupation of the Palestinian territory captured by Israel in 1967 as an illegal use of force, as an aggression. My argument that I'll set forward is one I first set out in an article that I was privileged to have published in the Palestine Yearbook of International Law, and I pay tribute to that fantastic journal, not just because they published me, but because they are a great journal and with a wonderful editor, Nima Sultani, and anyone thinking of publishing in international law should consider that great journal as somewhere to publish on any subject, not just issues relating to Palestine. That article was entitled Using the Master's Tools to Dismantle the Master's House, International Law and Palestinian Liberation. And it was also the basis for an Opinio Juris blog post in November last year entitled Israel's War in Gaza is not a valid act of self-defense in international law. This argument, my other argument concerning the illegality of the occupation as a violation of the law of self-determination, was adopted, these arguments, as the position of the 22 states of the Arab League in the advisory opinion case. The overall argument I made in the Palestine Yearbook article, which was adopted by the General Assembly in the question it put to the court, and was followed by the League and many other parties in the case, and adopted by the court, was that it was vital to address the question of the legality of the occupation in terms of not only its conduct, but also its existence. What I also argued, which again ended up being adopted by the League and many other parties in the case, and in turn the court itself, was that the law determining existential legality is the law of self-determination and the law on the use of force. Beginning then with self-determination, my academic argument, again adopted by the bodies I mentioned and the court itself, and also Francesca Albanese in her first report as Special Rapporteur on Human Rights in the OPT, was that the occupation is existentially illegal as a violation of the self-determination right of the Palestinian people. What then of the law on the use of force? Again, the argument I made, which was adopted by the League, many other participants, and the court, was that the occupation is illegal as a violation of the prohibition on the acquisition of territory through the use of force. However, this is not the only basis on which the occupation's existential legality must be addressed when it comes to the jus ad bellum in particular. As I said to the court on behalf of the League, and the court affirmed, Israel's exercise of control over the Palestinian territory captured in '67 as a military occupation is an ongoing use of force. And as such, its existential legality is determined by the law on the use of force. What I want to address now then is what the jus ad bellum position is on the use of force as a general matter, beyond the specific issue of using force to annex territory. My academic view on this, which I put to the court on behalf of the League, was as follows. As we know, the Gaza Strip and the West Bank were captured by Israel from, respectively, Egypt and Jordan in the war Israel launched against these two states in Syria. Israel claimed to be acting in self-defense, anticipating a non-immediately imminent attack. However, there is no such anticipatory right to use force in international law. Moreover, even if there was, for the sake of argument, the justification expired after the end of the 6-day period. Israel could not therefore lawfully maintain this force to retain control over the territory, let alone to do so for more than half a century. The occupation was and is, therefore, a use of force without a valid ad bellum legal justification, and in consequence, it is illegal on that more general basis. What then of Israel's current military action in Gaza? Well, given what I've just said, this is not a war that began in October 2023. It's a drastic scaling up of the force exercised there and in the West Bank on a continual basis since 1967. A justification for a new phase in an ongoing illegal use of force cannot be constructed solely out of the consequences of violent resistance to that illegal use of force. Otherwise, an illegal use of force would be rendered lawful because those who were subject to it violently resisted. Circular logic with a perverse outcome. More generally, Israel cannot lawfully use force to control the Palestinian territory for security purposes, pending an agreement providing security guarantees. States can only lawfully use force outside their borders in extremely narrow circumstances. Beyond that, they must address security threats non-forcibly. Now, the court didn't pronounce on this question of general jus ad bellum illegality. Instead, it focused only on jus ad bellum illegality arising out of purported annexation in particular. On the basis of finding this illegality, and the finding that the occupation constituted a violation of the right of self-determination of the Palestinian people, the court concluded that the occupation was existentially illegal and therefore should be brought to an end, and I quote, as rapidly as possible. What I want to suggest is that this overall finding had to imply a determination on the general ad bellum matters I've just reviewed. By disposing of the question of the existential legality, having characterized the occupation as a use of force, the court necessarily had to have already dismissed the validity of any jus ad bellum justification, such as self-defense, for this use of force. Had it not done so, it couldn't have concluded that Israel had no right to maintain the occupation, which of course it did conclude. The fact that the court didn't expressly reject the validity of any jus ad bellum justification, such as self-defense, doesn't alter the fact that by characterizing the occupation as a use of force and determining that as such, it was existentially illegal and therefore had to end as rapidly as possible, this rejection was, I would suggest, implied. Equally, although the court's determination of illegality in the jus ad bellum was specific to the issue of purported annexation, its overall finding of existential illegality applied to a presence it had expressly characterized as a use of force means, of necessity, that the occupation is a use of force that lacks a valid legal justification, and as such is, as a general matter, illegal in the jus ad bellum on this second, more general basis. Finally, although the court didn't use the term aggression, the jus ad bellum violations it determined to be taking place, both expressly a purported annexation through the use of force, and I would suggest impliedly a use of force in the form of an occupation without a valid legal justification, they are universally regarded to be paradigmatic examples of jus ad bellum violations that constitute aggression. In effect, then, to conclude, Israel's use of force, enabling it to control the Palestinian Gaza Strip and West Bank since 1967, has, in effect, been characterized as aggression by the ICJ. Thank you.
Great. Thank you, Ralph. Next up is Adil Haque, professor of law at Rutgers Law School.
Thanks, everyone. Thanks for having me. So Atha had asked me to discuss South Africa's case against Israel at the International Court of Justice under the Genocide Convention, and I'm happy to do so. But given what Israel is doing in North Gaza now, I want to start on a different note and propose that South Africa should return to the court immediately to seek additional provisional measures. Before going forward, I want to acknowledge two things. The first is that South Africa is very busy right now. Their memorial to the court is due next week. However, I think the urgency of the situation warrants a change of strategy at this moment. The second is, of course, that Israel has violated the court's previous provisional measures orders to one degree or another. Nevertheless, this is a legal tool that we have available to us. I think it should be used. And when you use a legal tool, you don't know the effect that it will have. In international law, you throw a stone into a pond, you don't know where the ripples are going to end. You don't know what political dynamics you're going to set into motion or what change you can make on the ground. So any tool we have available to us, we should use in any hopes of potentially saving lives. So in terms of the new provisional measures, I would suggest that the South Africa appeal to the court that there is a new risk of a genocide within a genocide in northern Gaza. The proposal should be very straightforward: to halt the military offensive in northern Gaza, to allow humanitarian workers in and civilians out if they wish to leave, which many will, given conditions there. The legal criteria are straightforward and I think very easily met. First, there has been a change in the situation since the court's prior orders, which those orders did not fully address. At the time of the court's last orders, they were focused on Rafah. Northern Gaza was in a very different phase of things. So things have very much changed in Northern Gaza. And there is a further risk of irreparable prejudice to rights under the Genocide Convention, specifically the right to be protected from acts of genocide. For those of you wondering, is there any difference between a real and imminent risk, irreparable prejudice, a right to be protected from acts of genocide, and a risk of genocide? The answer is no, these are equivalent. And so new provisional measures are warranted. Sultani, who's been referenced, cited me that South Africa should also appeal to the court to order a complete halt to Israel's military operations in Gaza. I agree. The last time South Africa made this appeal, it did not succeed, but if we read the separate opinions, we know that 7 judges were prepared to order Israel to halt all military operations. So South Africa really only needs to convince 1 or 2 more judges, and it can do so, both because of the severity of the civilian suffering, but also because to the extent that any judge is moved by Israel's claims of self-defense or security interests, those have obviously diminished since May. Hamas is largely disabled. President Biden said in May that it cannot commit another October 7th-like attack if it wanted to. So it is possible that 1 or 2 more judges may find that now is the time to tell Israel to just stop. So that is my kind of initial proposal. The second thing I wanted to say is that when South Africa submits a memorial to the court next week, I think it should add an additional claim. It's genocide within a genocide idea, both because I think it has merit, and also because it may itself have some effect on the way other states view the ongoing situation. And the outline of the argument is quite simple. So genocide involves the intent to destroy a group in whole or in part. And the ICJ has said in the past that a part includes members of the group in a geographically limited area that is distinctive. And again, all those conditions are met here in Northern Gaza. These are hundreds of thousands of people in a geographically limited area, and an area that has a distinctive place in Palestinian life, history, culture, and society. And it is another claim on which South Africa, I think, would have a good chance of prevailing and may change Israel's assessment of its own legal risk. So we may see. The other thing to watch for next week is if South Africa modifies the argument that it sketched in its original application. So that argument was that Israel intends to destroy the Palestinians of Gaza as a substantial group, part of the Palestinian group as a whole. And it intends to do so not primarily through the bombing campaign, but through a combination of displacement, starvation, and systematic destruction of hospitals, food, water, infrastructure, and as well as direct attacks on civilians. And that argument made a lot of sense when South Africa first brought its case, because Gaza itself is a geographically limited area. Population is certainly a substantial part. And also because South Africa was looking ahead. They were thinking about, they were asking the court to order as a provisional measure that Israel cease its military operations in Gaza as a whole. And to justify that request, it made sense for South Africa to say that the entire civilian population of Gaza is at risk of destruction. As we enter the next phase of the case, it will be interesting to see whether South Africa modulates its argument in one of a few ways. So the first is that when the court in the past has talked about what constitutes a substantial part of a group, it has talked about a geographically limited area, but it has also talked about opportunity, the opportunity of the perpetrator and how many members of the group it is able to kill, starve, and so on. And I think the concept of opportunity takes on a different shape in this conflict, because opportunity is shaped in part by what Israel is, how Israel feels limited to the extent that it does by its reliance on outside parties, mainly the United States. And so the approach that Israel has taken is sort of strategy of starvation, and has a particular character, because when you starve a population, when you deny them medical care, you don't know exactly who you're going to kill, but you know it's going to be members of the group, and you know it's going to be a lot of members of the group. And so when we think about the intent to destroy group in part, the part, right, I think can be a large number of members of the group killed indiscriminately, because what the court wants to distinguish genocide from is the targeted killing of one individual after another, even if based on group membership. They want to say that's not genocide, war crimes, that's something else. Might be the crime against humanity of persecution. But when your strategy is one of killing large numbers of members of the group, whoever they might be, I think South Africa should argue that that itself can constitute a substantial part of the group, and the intent to destroy such a substantial part. Another line of argument that I think South Africa might explore is the idea of genocide as a means. So this is something that Judge Kankata suggested in one of his separate opinions in one of the earlier genocide cases. And this is the idea that when you have an armed conflict and a genocide happening at the same time, genocidal intent and intent to defeat the adversary will occur simultaneously. But sometimes one is nested in the other. Of course, you can intend to defeat the enemy in order to commit genocide, but you can also intend to commit genocide in order to defeat the enemy. And if the intent here is to destroy a large enough part of the Palestinian group to force the capitulation of the adversary, in this case Hamas, I think this would fit within this genocide as a means framework. And the final possibility, which I'll be interested to see if they explore, is the idea that if you intend to destroy a group or defeat the enemy, whichever comes first. Right? So the idea is, if there's no intent to ever pull back, right? There's no number of civilians at which point you'd say, okay, enough, we're going to change our approach. You will just continue to kill and kill and kill until one of two things happens. You defeat your adversary, or there's nobody left. And in my view, that can also be understood as a form of genocidal intent. Remember, all genocidal intent means is that the intent to destroy the group in whole or in part has to be part of your intent. But it doesn't have to be the whole of your intent, and it can relate to your other intentions in a variety of ways. So these are all alternative legal strategies that South Africa might take, any one of which I think would change Israel's legal risk assessment. As long as South Africa stays within framework it originally set out in its application, I think Israel probably thinks it can win on the facts at some point in the future. If South Africa changes its approach, that may scramble Israel's legal risk assessment, and potentially that could lead to changes on the ground that could potentially save lives. I'm not saying that this is a high likelihood, but the stakes are very high. So if we can save anyone, we should. And I think these are some ways that South Africa might be able to do it, and it is worth a try.
Okay, next up is Professor Adil Haque of Tulane Law School.
Everybody just turned is looking at me now. Well, thank you for showing up. It's good to see old friends there in the room. It's good to see some old friends also, the attendees, and from Palestine in particular, but across the world. We thank you for a very healthy turnout. It seems people were really excited about joining this. Even I saw some comment in the beginning when we were taking late. Somebody said, "Hello, start, hurry." And it seems that there's a lot of interest in this discussion. And I am particularly happy with the very Palestinian lineup, which makes me very proud to see my friends, colleagues, brothers, and sisters presenting on very important issues in relation to the ongoing situation and in our representation of the Palestinian people. The one thing I'm going to be speaking about the ICC in particular, but the one thing I would like to just briefly mention is that in a lot of the discussion, I think we do need to engage in a little bit of a rethinking of international law in terms of state responsibility in particular. This report that came out today or this morning or yesterday with respect to Al Jazeera and the intelligence and military operations of the United Kingdom, the United States, and others that may have involved, it really gives us somewhat of a clear picture in terms of the assessments that have been made with respect to whose war this is, in terms of who's carrying out this war against Gaza and against the Palestinian people. And I think that sometimes, at least for somebody that has worked within the human rights community for a long time, sometimes the advocacy was misplaced. And what I mean by that is that we were asking the U.S. to pressure Israel to stop when we should have been asking the U.S. to stop. And I think that's something that requires a little bit more thinking in terms of the work that we do as human rights advocates. Now on to the history of Palestine International Criminal Court. I won't go too deep into the history. It's a very long history. I have an upcoming law review piece that I hope doesn't get the Rabea treatment and get censored at some point. But it's going to be on Palestine and the ICC. The relationship with Palestine and the ICC goes back to 2008, 2009, with respect to the Gaza conflict and so-called Operation Cast Lead and the Goldstone Report and whatnot. And back then, there was a 12-3 declaration that was made by the Palestinian government requesting the court's jurisdiction. So it goes back about 15 years over the course of 3 prosecutors, Luis Moreno Ocampo, Fatou Bensouda, and currently Karim Khan. At some point, with the kind of the delays that were going on in terms of how Palestine was treated at the ICC, what we saw was there were claims of institutional failure and bias. And this was something that John Dugard had presented in 2013, 2014. The institutional failures and bias sometimes operate independently. Sometimes they reinforce one another. And in many cases, it's really the institutional failure that kind of gives rise to the individual bias within the court. And what I mean by that is that, you know, the institutional framework itself, such as the provisions on the UN Security Council or on jurisdiction or admissibility within the Rome Statute of the International Criminal Court, really kind of paved the way for the ability for the court to operate or individuals within the court to operate with individual bias. And a lot of this is influenced, I believe, and many others have written on this as well, especially in the past decade, on issues of power and race and other factors, similar factors, imperialism, colonialism, and whatnot. Basically, all of these factors are virtually unchecked through prosecutorial discretion, which many of us, of course, support because we support an independent prosecutor. What this means is that most decisions with respect to the prosecutor, such as non-decisions or delays or budgetary concerns or cooperation or complementarity or gravity, is virtually left unchecked by any other organ of the court. And it's really up to civil society to kind of put that kind of pressure. There is the interest of justice, which I'm not going to discuss in detail, which is kind of the only one that really can be checked by the judges. Other than that, the decisions of the prosecutor are left to the prosecutor for the most part. So it is largely OTP based. So a lot of the criticism on institutional failure and bias is largely focused on the OTP. Of course, that's without prejudice to possible issues arising from other organs of the court, including the judges, including the registry and whatnot. And what are some of these criticisms? Some of these criticisms include the overt focus on Africa, deference to the West. So we look at the UK, the investigations into the UK's actions in Iraq, the investigations of the United States into Afghanistan, the investigations of NATO into possible crimes committed in Libya, and overall stalling on Palestine, or at times coming to a complete halt. And that stalling or delaying, as you know, we still see it today, right? But just not as much as before. At least there's some movement, and we're updated to a certain extent on the progress and all that. But back in the day, we were kind of left in the dark, especially with the first prosecutor, Luis Moreno Ocampo. In that particular case, what we had was, after 3 years, we had a 2-pager, basically Ocampo saying that I'm making a determination not to make a determination on how to move forward with Palestine, in a nutshell. Bensouda also kind of leaving everything to the tail end of her tenure, requesting affirmation from the judges on the territorial scope and all that. But within time now, I mean, where we are today is, the focus on the current configuration of the Office of the Prosecutor. In the first 2 years, Khan's tenure really didn't have much to say, little to nothing to show on what was being done on Palestine. And there have been some things with respect to, we put a person here, we got some budget, including these little hints here and there, but nothing really to show any real substantive progress on Palestine, and which resulted in what I believe was justified criticism. Other situations, we saw there were questions about transparency with this new OTP and all that stuff. But eventually what we did have was a significant shift, right? What we have today is a request for arrest warrants that have been made by the current prosecutor, by Karim Khan, against 2 high-level officials, largely seen as within the West, Netanyahu and Gallant. And you will see that kind of the outrage that has come from the West against it is really, in my opinion, racially based, right? You don't go after our people, right? You don't go after the West. But it's completely fine to go after other states. In that small period until then, right, it was post-October 7th, the handling of the situation wasn't great. The messaging was off. Scholars and practitioners alike were not entirely, in my opinion, critical, and some of them, to a certain extent, even participated in the post-October 7th mob, which resulted in a complete indifference towards Palestinian lives, something that we need to reflect on as scholars and practitioners. And we also had, even till today, we have no indications on investigations and prosecutions for other international crimes, settlements, persecution, apartheid, genocide now, right? And notwithstanding a genocide within a greater genocide that has occurred, or which Rabea has kind of referred to in within the concept of the crime, or the Nakba crime. But nonetheless, and it's important, of course, not without critique, the decision that has been made does have certain legal and ethical bases in which to critique, such as the classification of our conflict. But I think what's important is that at the very least, a decision has been made. A determination has been made after 15 years, where the court has actually requested, or the Office of the Prosecutor has actually requested, the issuance of arrest warrants against 2 high-level Israeli officials at the highest level, right? And I think, or my hope is, that it paves the way for a more comprehensive justice, one that trickles down to every soldier that has posted, their war crimes and other international crimes on social media and whatnot. Now, in the process since then, with the couple minutes I have left, and I'll just mention, in the process since then, there have been further delays, right? And also not without critique, while inviting Amaikai and Israel's challenges on jurisdiction and admissibility. And what you see is that there have been these stages where there are challenges from Israel and allies to try to stop the court, right? And I think the fact that right now they're throwing the kitchen sink at it means that we might be closer to the possibility that these arrest warrants may be issued. I hope that is the case. I hope that we can prove once and for all that the court is fair, independent, and effective in International Criminal Court. We see that they have thrown the kitchen sink and gone to the lowest levels now, right? With the smear campaign against Karim Khan. Once you hit the smear campaign, you know that you're desperate. in my opinion, right? It's just a certain level of desperation, seeing that nothing else kind of has worked. I think now it's important for states, and we do see some shift, particularly within states parties of the Rome Statute that had sometime in the past pressured the court against investigating and prosecuting international crimes in Palestine, now supporting that possibility. And I think my hope is that, I think that at some point in the near future, we're going to look back at the ICC and these other international mechanisms, and we're going to look back and we're going to say we failed. Right? We failed. We said never again, and we didn't actually mean it. And I think, like the attacks on the court, what we're doing is we're only delaying these inevitable determinations. And my hope is that, as now an academic within the legal community here in the US, and I think for the global legal community, legal academic community, and others, is that we stop silencing these voices, particularly on campus, and that we could speak about these determinations that are inevitable, something that we won't be ashamed of when we look back and say, yeah, that was us. We took part in this mob, or we took part in the silencing of these voices. Thank you.
Of Queen's University of Belfast, who has a presentation.
Right.
Please, tomorrow begin.
Hello, everyone. Just 1 second. I am sharing my screen.
Yes, we
Can
see
you
it
see
now.
my screen?
Oh, is it?
Yes.
Okay, excellent. Yes,
Now full screen.
excellent. Thank you very much, Omar, for these introductions. I am delighted to be here with all of you today to present about bottom-up transformative justice as a decolonial alternative to the liberal peace paradigm in Palestine. I don't want to spend a lot of time to talk about the failure of the liberal peace paradigm, which is the predominant mode of engagement by the international community with the question of Palestine. We all know that this paradigm has failed, both historically, but perhaps more crucially, since the beginning of the Oslo peace process here. I'm happy to discuss a little bit more in the questions and answers what were the assumptions that have led to the failure of this liberal peace here, but I think everyone who is attending this webinar would already know about this. But apart from the failure of these assumptions here, we can also see major gaps pervading the liberal peace paradigm, not only at the level of the conceptual framework, but also in terms of inclusivity, and perhaps most importantly, imposing solutions from the outside and in a top-down manner. And because of this unequivocal failure to deliver peace in the question of Palestine, my PhD research proposes bottom-up transformative justice as an alternative, which refers to centralizing Palestinian voices and perceptions of justice at the core of any political process and at the heart of any peace proposition, which I put into action in my PhD research. To give a quick overview of how I do this, my fieldwork is designed to capture Palestinian perceptions and views on justice at the level of political solutions and at another level, which is accountability, prosecution, and reparations measures. And because I cannot cover all of the atrocities committed by Israel, I focus on Israeli settler colonialism. In terms of the geographical coverage, I solicit and capture the views of Palestinians inside the Green Line, Palestinians in Jerusalem, and Palestinians in the remainder of the West Bank. And I include internally displaced Palestinians and refugees from each of these areas. I cover the views of Palestinians in two main streams. The first stream is the general Palestinian public, and I cover these through 165 survey questionnaires. What I mean by general Palestinian public, I mean is ordinary Palestinians who live daily under occupation and Israeli settler colonialism. I have ensured diversity in the selection of respondents to account for intersectional identities that further marginalize the voices of vulnerable social groups on the grounds of gender, age, place of residency, refugee status, educational attainment, and socioeconomic background. I was also intended to do 8 focus group discussions that include 50 to 60 participants to delve deeper into the survey findings. But ultimately, these focus groups were cancelled due to the political destabilization since October last year and the associated security risks. In terms of the second stream, which focuses on societal actors, I cover the views of public figures, political figures, academics, the business community, and civil society organizations working in human rights and the Palestine question through 28 individual interviews. What have my findings revealed? And I note here that these findings are based on the survey. I'm happy to comment whether there are differences or similarities with the views of societal actors on these in the questions and answers section. I will start with the findings at the level of the political solutions and whether my respondents have a preference for political solutions or accountability, prosecution, and reparations measures. The study or the survey reveals that 11.5% prioritize political solutions and that 25.5% prioritize accountability, prosecution, and reparations measures, but that the vast majority, above 60%, they see both as equally important and go hand in hand. And what this shows is that the focus of the international community as part of the liberal peace paradigm solely on a two-state solution does not really reflect the aspirations of Palestinians. In terms of the preferences on the political solutions, which were determined by the presence of these options in the top 3 choices out of a possible 9 options, the highest priority came to be is ending the occupation, standing at 77%, followed by the recognition of Palestinians and their right to exist, standing at 76.4%. This was followed by the shape of statehood that these persons have chose, which I will get to in a little bit, standing at 62%. And in 4th place, the recognition of Palestinian indigeneity, standing at 53.3%. On the shape of the political solution, support for the two-state solution stands at 10.3%, followed by one binational state with equal collective and individual rights for all of its peoples, standing at almost 25%. And coming in top priority, or the top choice, is a one state with full Palestinian sovereignty, with 65% of the respondents. Of these 65%, or 90% of these 65% envision the state to be religiously pluralistic, democratic in its nature, with equal individual rights, including religious and cultural rights. These findings are not very surprising because we could see in public opinion polls the erosion of the two-state solution in the public view, whereby support for the two-state solution stood at 32% in September 2023 in a public opinion poll conducted by the Palestinian Center for Policy and Survey Research. This is compared to 82% in 2012. Also, in the same September 2023 public opinion poll, 71% of the public believe that the two-state solution is no longer viable due to settlement expansion. At the level of accountability, prosecution, and reparations measures, the top three priority here, and these were also determined in their presence in the top three choices out of a possible 10 choices for this category. The top priority was the right of return of Palestinian refugees, standing at 78.8%. Followed by prosecution of Israeli officials who committed international crimes before the International Criminal Court, standing at 44.2%. In third place came restitution of property for Palestinian refugees, standing at 42.4%. And in fourth place, truth recovery of the Nakba and currently lived realities of colonization, displacement, and apartheid, with 40.6% of the respondents. On the other hand, the least priorities under this category, which again is determined in their presence in the top three options out of a possible 10 options. The least important priority is the commemoration of the Nakba, standing at 5.5%. Second is provision of a public apology by Israel, standing at 7.3%. And in third place, guarantees of non-recurrence of mass atrocities and human rights violations by Israel, standing at 15%. I would like to just zoom in a little bit and speak a little bit about the right of return, because apart from that, the right of return.
About 1 minute.
Yes, this is my last slide.
Okay, go ahead.
Right of return of Palestinian refugees being considered a priority, the top priority by 78.8% of the respondents. This figure rises to 82% of the respondents who chose at least one of three refugee issues in their top three priorities. And here we refer to the right of return, property restitution, and compensation of refugees. These are also seen as a package and as indivisible because 63% ran the options equally or consequentially, and only 4.8% of the respondents did not evaluate the right of return as very important. This figure decreases to 0.6% of the respondents who did not evaluate it as very important or important. What this tells us essentially is that the liberal peace paradigm and its approaches, there's a very wide gap with the aspirations of the Palestinian people, and that for the prospects of an effective and sustainable peace, this requires a reshaping of the peace process and proper integration of Palestinian voices. Thank you.
Thank you, Tamara. Okay, we have a bit more than half an hour for questions. Law for Palestine has kindly collected 5 questions, and I would imagine from our live audience we'll have a few more. Would you like me to give 2 or 3 and then open it up? Okay. Question 1. Can or should the Nakba, both in its historical and ongoing international context, e.g., treatment of Palestinians and their supporters outside the Middle East, also be classified as ongoing anti-Palestinian racism? Would this classification help prevent harm and empower victims to seek legal and institutional remedies? These are long questions. Should I continue? Okay. Take notes. Question 2, regarding obligations and commitments. There is an inextricable link between the deliberate policy of denying aid to Gaza and Palestine with the crime of extermination and genocide. Is there a way through legal action to force third states, i.e. the UK and US, to stop the nonsense about urging Israel to facilitate aid in the context of Israel's admission in the Israeli High Court case brought by Gisha and other organizations where the state admitted this policy? Can we force states to act on their obligations regarding aid, or else be seen as complicit in genocide and extermination. One more? Is that enough? All right, one more. Question 3. Are the many examples of Palestinian exceptionalism effectively instances of anti-Palestinian racism? So the theme there. How can the CER, the International Convention on the Elimination of All Forms of Racial Discrimination, be utilized, for example, by the Global South to hold governments accountable? I'll stop with 3.
Sure. So if I get the question correctly, should the Nakba be understood in terms of anti-Palestinian racism as well? Well, I think the Nakba is a product or a material manifestation of anti-Palestinian racism that has been embedded in, the doctrine of settler colonialism in Palestine. And in this sense, I do want to note, for example, that, many times the emphasis of the Nakba for me is important because it is shifting the discourse from let's put it this way. In 1975, the UN adopted a resolution that declared Zionism as a form of racism, right? And we know that in 1991 this was rescinded as part of the package of the so-called peace process and entering into the Oslo negotiations under American lobbying and diplomacy at the time. Now, some people say and argue that Zionism is some sort of, should be defined as some sort of Jewish self-determination claim. Some people do say, for example, Zionism is colonialism, but it's also other things as well. For example, Zionism is both colonialism and nationalism. What I'm trying to say about the Nakba in this sense is that we need to define Zionism from the perspective of its victims, right? Which is obviously a point made by Edward Said already in the 70s in his famous essay, Zionism from the perspective of its victims. I don't understand why, we don't allow this nuance. I mean, sure, Zionism could be potentially many different things, but I don't understand why there must be some red line at which we draw and we say there are certain ideologies that cannot be understood as exceptionalizing their victimhood. That certain ideologies, we don't do it with, for example, Afrikaner nationalism. We don't do it because we understand that it birthed apartheid and we understand it as to be constitutive of this ideology. We don't do it with Nazism because we understand that Nazism birthed the Holocaust, right? And it's a racial ideology that is must be defined from that perspective. Therefore, for me, we need to define this Zionism or ideology of Zionism as Nakba. We need to understand that Zionism led us to the Nakba. And therefore, we cannot exceptionalize these two concepts, one from the other. And so going back maybe to the question of is Nakba a form of Palestinian anti-Palestinian racism? I mean, of course it is in a way. But I would say that it's even more than that. It's not only racism. It is a material manifestation of that racism baked into our international legal structures.
Okay, so can I take the moderator privilege because we have a second question about Palestinian exceptionalism as anti-Palestinian racism. So you have complicated geopolitical issues that have been litigated through the CERT framework. You have the isolation of Qatar by the Gulf states, the expulsion of Qatari nationals, but in the context of trying to punish Qatar for its autonomy, right, relative to Saudi Arabia and the other Gulf states. You have the CERT being invoked in the Artsakh or Karabakh situation, the expulsion of Armenians from Karabakh, and also the treatment by Armenia of Azerbaijanis living in this territory controlled by it. So those are very complicated situations, and yet the CERD and the treatment of this as racism, okay, it doesn't encompass the entire situation, but it's one attribute of it. Do you think that pursuing Nakba as anti-Palestinian racism has utility, or is it problematically limiting?
I mean, I think the notion of anti-Palestinian racism is another notion that needs to be recognized and dealt with. I mean, I don't think we deal with anti-Palestinian racism on par with how we deal with anti-Semitism, for example. And we need that. We need to be able to name these kind of phenomena, right? And that's partly what the Nakba is trying to do. It's trying to give a name to name a certain phenomenon that is deeply racist, of course, but it's more than just racist. I mean, I personally don't think that in terms of our legal structures here at play, racism is the necessarily go-to legal framework that we need to utilize. And so, you know, I don't think I think there is space for pursuing all these different things at once. You know, you can talk about the Nakba as an ongoing, both material manifestation of Palestinian subjugation, domination, fragmentation, and dispossession over time. But you can also go a different route and try to name this anti-Palestinian racism in law. And these two, I mean, I don't think of them as necessarily separate, but I don't think the Nakba as is the name for anti-Palestinian racism. I think it's a manifestation of that racism. It is a framework that allows us to name the crimes against Palestinian people. That again, anti-Palestinian racism is kind of looming over this crime.
Mm-hmm. Okay. Atta, I see you have your hand up. Oh, we can't hear you, Atta.
Thank you. Just the only thing I'll add to that, I've been fascinated with Rabea's contribution to the discussion of dealing with crimes over the course of our history. And I certainly see the utility in looking at the Nakba as a context, right? As a contextualization for all of these crimes that have been committed against the Palestinian people, and in particular, what is eventually meant to ensure the denial and erasure overall of Palestinian identity. It means at the very least we can make them Arab as long as they're not Palestinian, and this really provides, I think, in my opinion, a context, a conceptual legal framework in which we can address all of these crimes. In terms of anti-Palestinian racism, this is something that is both explicit and implicit. It exists everywhere, and it is the product of so many things, right? It's the product of the Nakba, it's the product of strategic political interests, it's the product of so many things. At the end of the day, it also comes to the same thing. It means that what we need to do is we can see to what extent, at least in terms of how do we symbolize and represent Palestinian identity, that we can find ways that we can, as I've mentioned before, outright ban it, like the Palestinian flag, how we can at least restrict or limit it, like the Palestinian kufiya, or at least how we can find a way to reappropriate it, like the watermelon, right? So these different ways and strategies in which we can, which all results in one end goal, which is the erasure and denial of Palestinian identity, which allows, even in our context in the legal academy, allows us to engage in anti-Palestinian racism and get away with it.
I want to give question to obligations and commitments. Is there an inextricable link between the policy of denying aid to Gaza and Palestine with the crime of extermination and genocide? So this is one of the assertions made of this contentious case brought by Nicaragua against Germany, which almost certainly will not be decided because of the absence in a contentious case of a directly affected, indispensable third state, which is Israel. But that is the claim, that it is both the provision of military assistance by Germany as well as the suspension of German humanitarian aid at this particularly sensitive time. Does anybody have thoughts about this? As suspension of aid, as complicity in genocide?
Well, I think so. I think one difficulty there was that while Germany suspended contributions to Ottawa, they had continued other forms of humanitarian aid. And so the court essentially said there's no specific obligation to give aid in a particular way or to a particular group. And Nicaragua's initial claim was that the suspension of aid was both a violation of the duty to prevent genocide and was also tied up in Germany's obligations as party to the Geneva Conventions. And the court, as I read it, was not willing to speak to that directly. And if anything, sort of shied away from saying anything about what exactly the duty to prevent genocide or to ensure respect for IHL really means concretely. Clearly, Germany's argument was that talk is enough. As long as we ask Israel to please stop violating IHL or not endanger the survival of the civilian population, we've discharged our duties in that regard. The court never, in my view, really spoke to that. All it really said was that on the current state of facts, we don't think Germany is giving the kind of military aid that would create further risk of irreparable prejudice to the rights under the Genocide Convention. And so that's why the court declined to issue provisional measures at that stage. Things may change both because Germany is now saying that it will resume shipping, I forget what they call it, war weapons, I think is the term for it. So that may change if the case reaches the merits and somehow they get around the indispensable third party problem. But that's sort of where I see it. The court was very unwilling at this stage to really say much about what this obligation is doing.
But let's keep you on the spot. I have a question that is attention, Adil Haque.
Okay.
On the relationship between IHL and genocide, you spoke today and previously tweeted in regards to the US government confirming that Hamas cannot commit another October 7th again. In your view, from that point onward, with Israel's ad bellum war aims being met, is this now genocide masked under an unjust war?
So I can imagine another scenario in which a state achieves its legitimate defensive aims, which is to halt and repel an ongoing armed attack, and according to some, not me, to ensure that attacks do not sort of immediately resume. And yet the state just keeps going and trying to kind of pulverize their adversary, but not necessarily with genocidal intent, just a kind of ruthless pursuit of total victory. I don't think that's where we are in Israel and Gaza. I think that these things, as I sort of suggested, are kind of bound up with one another. But the other thing that I would say is that, so I mentioned in my remarks that I think the case for provisional measures calling for an entire cessation of Israeli military operations in Gaza is stronger now because Hamas has been degraded so much. The flip side of it is that, unfortunately, I think what we see in North Gaza now is a much stronger case of genocide on the merits. So I think that when the case goes to the merits, unfortunately, what Palestinians are living through right now may end up being the basis for a judgment against Israel. Obviously, we would rather it just not happen. But in that sense, I would say that in some ways, the case for South Africa's case has gotten stronger because Israel's conduct has gotten worse in a way and less tolerable or explainable. It's responsive.
Sure. Okay. Another audience question, then we'll move back to the questions collected by Law for Palestine. On reparation and remedy, all of these positions have depended on reconfigurations of international legal reasoning. How do they all suggest reconfiguration? I guess, how do all of you suggest reconfiguration of reparation, which is thoroughly rooted in a framework of state obligation? How may we address the refusal of submission to law?
Well, I'll just throw it
Open to all of you.
Yeah, so I just want to throw out one thing, because I think that there are a lot of really smart young scholars who really want to make a contribution on these issues. And so if they're listening, one topic that I think it would be great to have somebody really dig into is reparations for violations of provisional measures order. Because the one thing I'm very sure of is that Israel is definitely going to lose on that. And so it will really matter whether reparations can be ordered just for that.
So one remote question in that regard: what are the consequences of Israel's violation of provisional measures for the state sending arms to Israel?
Okay, state sending. So actually, also a really good question. So one way of thinking about provisional measures is that they're sort of obligations to the court. And that has very limiting implications, because that means they don't necessarily entail new obligations on third parties. And also it might suggest that reparations would not be appropriate because there are no rights conferred on the affected population. So I think that it would be very good for people to argue for an alternative conception, where these are obligations that third parties also should not contribute to the violation of, and also that the beneficiaries of these provisional measures do acquire a legal interest, which, if violated, should entail a duty of reparation. I don't think that we're there yet, but I don't think the court has slammed the door on it either. I think there's still room for creative legal argument.
We have the precedent of the consular relations cases involving the United States, where the provisional measures are do not execute this foreign national. The U.S. does, and not much ensues. Okay. A question from the remote audience. Has Gaza exposed that the power of international law is limited to the extent that it doesn't threaten existing imperial power dynamics? And if so, would our energy be better placed to shifting the balance of power in the world as a better approach to achieving Palestinian liberation, even if that may diminish or threaten our own individual positions of power and privilege within the current systems of power dynamics?
Yes.
Well, I thought that
Care to elaborate?
I mean, I think that it's yes, and also that is exactly the function of everything that we are doing within the framework of international law. This idea that it's, the law and the courts versus whatever other form. It's found all of this work, whether how we think about the developments at the ICC, the ICJ, in US courts, in academia, like it is all actually about shifts of balance of power and calculuses that states have to make. And that is, I think that's like a fundamental, it's a struggle that I have a lot of how we think about the law, and how we think about the law as that side of struggle and what forms of sides of struggle, I mean, we talk about, not to use cliche terms, but successes without victory, which is, a term that one of the CCR founders kind of popularized, which is how do you think about our work in the courtrooms and in the halls of courts, courthouses, as not just about getting a victory in court, getting a ruling, in your favor, but actually about shifting the power calculus and the dynamics and you're elevating negative voices. So yes, we do need to shift the power balance. We do need to be thinking about the global. I think the fact that South Africa is the state that's brought the genocide case is really significant in terms of how we think about orientation. And so it is looking more, Palestinians have been looking more towards the global south, have been thinking about challenging empire and imperial dominance, and speaking very explicitly about the law as a function of empire, and still using it. So I guess that's just my 2 cents, and there are plenty of other scholars who have said this, very articulately, but just kind of breaking down that binary. Can I go back to the anti-Palestinian point real quick?
Sure.
I just want to reflect that my own experience of that term and that language has really come, I consider it to be a very US and Canada, North America centered term. And I'm curious about pushback on this point, and I would like to get, feedback on this. But I've experienced the emergence of anti-Palestinian racism as like a concept, really one that has come out of a North America discrimination centric way of thinking about the law, right? We have very few ways in which we can talk about power and race in the US. And so we have discrimination as a lens through which we see everything. And I know that there was a significant and meaningful push for describing and defining anti-Palestinian racism as a way to sort of respond to all of the ways in which the charge of anti-Semitism has been misused, right? And so I also just want to keep in mind that this language comes from legal legacies and ways of thinking that aren't necessarily what I love about the Nakba and what I like about the language of settler colonialism is that it's a more layered, less flat version of what is anti-Palestinian racism, right? And so I just kind of want to invite others to reflect on this question of, the utility of it and her response to what you were saying. Yeah.
But would you agree that the situation in the diasporic situation and the situation of the dialogue in the U.S. and Canada and elsewhere, the silencing of discussion on the Palestine question is in these areas, not in Palestine, anti-Palestinian racism?
Yeah, but then how do you address all the speakers who are not Palestinian who are also being silenced, right? I mean, there's a way to talk about that for sure.
Sure.
But it doesn't fully do it justice.
Sure.
In the same way that talking about the First Amendment doesn't do it justice, right? I mean, I think both of these are sort of limited.
Sure. Yeah. Tamara, did you have? I know that Atta has his hand up. Tamara, did you have an intervention you wanted to make?
I did have a question to Rabea here, but no, for Palestine. Thank you very much. I wrote it to them in the chat, and it will be disseminated there. Unless I can ask it now.
Yeah.
Okay. Rabea, I found your article on the Nakba very, very interesting. And of course, the whole fiasco around and the censorship around its with Colombia and all of that. I think it was very good publicity. It exposed a real big double standard, but I also think it was very good publicity. My question to you is whether when you were writing your article, if you considered other terminology other than Nakba. And the reason I ask this is because apartheid as a word, it was chosen by the white racist regime in South Africa. And over time, it came to have a very negative connotation here. So what I was wondering, or we could say the same applies for Zionism, because it was chosen by the Zionist movement. So maybe my question to you is, do you think it is worthwhile for us to work on exposing the real meaning of Zionism as racism, as settler colonialism, as white supremacy, as all of these things, so that over time it becomes an extremely negative term? Thank you.
Speaker.
Please.
Thank you, Tamara. Great question. Yes, I did consider that. I mean, and in fact, part of the article, I mean, the first part of the article is titled Zionism as Nakba. So the whole move is trying to actually recalibrate the debate in a way from being or again, from defining what is Zionism. And I already think Zionism is, for many, a very negative term. I would consider it an insult to be called a Zionist, for example, as should any reasonable person, I believe. And I think, Zionism as Nakba, defining it, it is true that in South Africa, you had a synonymous name for what the regime was, saying it was committing, and what the experience of the people was, right? So in Palestine, we invented a different terminology for kind of what Zionism did to us, and we called it Nakba, right? And we understood it as an ongoing experience. And again, I did not obviously invent the term Nakba, certainly not the idea that it is an ongoing concept. And that's what I feel is beautiful about it and powerful about it. It is an organic articulation of our community. You cannot pin down and say, this is the person who termed the word ongoing Nakba, right? But it is very common way to reference and understand our reality back in Palestine by many Palestinians, scholars, activists, generally people who go back to this constitutive experience of Palestinian loss and pain, which we term the Nakba. And I believe there is something powerful about choosing to define our reality in our own terms, right? Instead of choosing to define it in as a response to Zionism and as a response only. In fact, you can think about it as, even in the debate, I don't want to imagine a post-Zionist Israel. I want to imagine a post-Nakba Palestine. And that is something that the Nakba framework allows us to go back to, trying to center the perspectives and the imaginations of the victims of these ideologies, and trying to give a name and a voice to ourselves.
I'll have to go ahead. And then we're going to have a lightning round of questions.
Yeah, sorry. I'll keep it as brief as possible. Just not long after October 7th, I wrote a piece in Twitter titled "International Law is Dead," where I declared the death of international law. And I found that a lot of people engaged with it, though they didn't want to engage with it directly. So I had some complaints from other colleagues that I was being too harsh on international law. And I think because it kind of conceptualizes oneself as a walking contradiction, to work within law and to argue that it's dead at the same time. But I do have something at some point next year will come out on what I meant by all of that, but it's very fascinating to see how much individuals really took it serious when it meant that their trade was possibly no longer relevant. And it kind of goes to Wissam's question.
You're muted.
Sorry. It kind of goes to Wissam's question on the shift. If there's one thing I can predict from a political perspective, I do see that there's a shift to the global south. And this shift to the global south means that there is a real move towards strengthened numbers, power and permanent sovereignty over natural resources, real international cooperation and solidarity as legal concepts. Like, these are things that are actually happening in real time, but because they're happening slow, we don't see it. And I think that refocusing those efforts to Africa and Asia is important, because that is where I see the next kind of where the real international legal order is going to stem from, if I were to predict something for the future. Just the one thing I would add, just on terminology, like if you look at apartheid as a word, we became so fixated. When the court is dealing, the court has its own legitimacy to deal with, and there is a real threat from the United States and certain other states if the court says something that they really don't like, which means that they're a little bit more conservative in their actual decisions, including on provisional measures, which means that they're a little bit more careful, as opposed to advisory opinions where they don't have the possibility of someone just straight out not listening to the court or not doing what the court tells them to do. That they're a little bit more flexible in explaining what the law actually is, as we saw with the advisory opinion, right? We could see two Palestine related cases in which we saw kind of different approaches by practically the same judges, aside from Sebutinde, who was copying and pasting off of Wikipedia, as many probably was able to catch. But we shouldn't get fixated on the terminology, right? Because a lot of us were looking for apartheid. The Apartheid Convention specifically says apartheid is a crime against humanity and that inhuman acts resulting from the policies and practices of apartheid and similar policies and practices of racial segregation and discrimination. Institutionalized racial discrimination, right? That's what it is. And sometimes there's even a fear of saying that word, but essentially it's the same thing, right? It's the similar practices. It could mean something else. It doesn't necessarily have. And I feel the same way about how we term anti-Palestinian racism, or how we look at, like, these are not concepts and arguments that need to exist independently of one another. That we can all take these different approaches towards achieving the same thing. And it won't, international law itself is not going to emancipate the Palestinian people, but at least it may be a tool. And going through these different approaches, whether through scholarship or through practice, I think continues to move us on the right track.
Okay. Further to Rabea's point about a post-Nakba Palestine, if you had all the powers to shape the situation as you deem fit and appropriate, politically, legally, etc., what is your positive vision for this region in the future? Can these two communities co-live at some point, assuming no side will exterminate the other 7 million members of the other side in the eternal war? I think a positive vision is something that is absent in the discussion and yet extremely needed when for more than a year now the language cannot describe experience and helplessness is rife. So nobody wants to be positive, we'll move on.
I mean, I'll say go read the conclusion, I would say, of the toward Nakba as a legal concept and about the idea of undoing Nakba. And I think that's where we need to start thinking as well, as a next step potentially. But first, we need to recognize the problem in order to be able to solve it, right? And this urge to transcend very, almost rapidly to end solutions is something that I want us to resist a little bit. But if we insist, yes, I think we can have a vision of the future. I think we can think about undoing Nakba as a composition of that starts with recognition. Continues through return, reparations, redistribution, and reconstitution. And it's a package of, call it the 5 R's or what you will, but, it is exactly what I think goes back to what Jana was saying also about the power of the law. I mean, why we do what we do, why we're saying all of these things. Law has been instrumental, historically, particularly international law, in shaping our narratives, in making us reckon with certain atrocities in the past, right? And so we turn to law and to the idea of genocide after the Holocaust. We turned to law actually in the 70s, way before the apartheid regime fell, to theorize apartheid as a legal concept. And what I think this turn to law, to international law in particular, can make us do is to start a process of recognition, of reckoning, from which we later have to move on. Yes, after recognition can't be the end point. It can't be just semantic recognition. It needs to be translated into, as Tamara was mentioning, a huge part of the problem is the refugees, right? We can't talk about the Nakba or talk about Palestine without centering the refugees. It's not an external problem to the occupation. It's not an external problem but we almost feel like, we'll get to it later many times, right? And so, or the discussion gives us this sense that, we'll figure out, at some point we'll figure out how to negotiate the refugees issue. No, this is central. This is at the core of what the Nakba is. This bifurcation of the Palestinian people at this foundational moment into a group that gets not only dispossessed, but also displaced beyond the purview of the territorial unit of Palestine to begin with. Something that, for example, did not exactly happen in apartheid South Africa. And excluded from this territorial. So, just in a nutshell, I would say yes, we can think about positive visions in the future. We can, but we need to first start with recognition, then move to again reparations, reconstitution of the polity, and then within that framework, we can start discussing, 1 state, 2 states, 10 states. That's part of the redesign of what political frameworks will be at play after we resolve. Or after we are, on the same page about the recognition of the harms caused, the return of the refugees, and the reparations.
So if I can summarize, Rabea supports the 10-state solution.
No, but it's just because Tamara has been thinking about that and presents it to us. It was think about it empirically. I think that's important to hear. She has something to say about that.
I'm sorry, can you repeat that? There was some
I just wondered if you also had something to say about that question, because you are working on this, thinking probably about this question through your the empirical work that you do. Because it could be recognition, and then this, and then this, and then what people say it should be. Like, this is what I understood you're looking at, what people think should be.
Yes. One of the main things that I found that I found quite interesting is that the issues around the right of return came out to be in a very top priority level, doesn't compare to any of the other priorities. Like, we could see that almost 80% focus on right of return solely, and that this figure rises to 82% when we look at the issues that refer to Palestinian refugees here. In second place was prosecution for international crimes, and again, it speaks to the Palestinian need for proper accountability measures instead of symbolic reparations here. But that stood at 44%. There's a very large gap here between priority number 1 and priority number 2. So what this tells me in my findings is that it is uncontested for Palestinians the primacy of the right of return, property restitution, compensation for Palestinian refugees. What's also interesting is that this is one of the issues that did not create a gap between the general public, the ordinary people, and societal actors, because which are more elitist in their nature when we're talking about public figures, political figures, academics, business community, civil society organizations, and how these are very much intertwined with the liberal peace paradigm. There is an unequivocal consensus on the primacy of the right of return. That would be the first thing that I would say here. The second thing is a focus on, when we're talking about reparations and these things, there's a very large gap between concrete reparations and accountability and symbolic measures. We see that 44% have placed prosecution in their top 3 priorities of for reparations, compared to 7% who thought of provision of a public apology as a priority. Many people saw the issue of the apology as a symbolic measure instead of an admission of guilt here. When it came to guarantees of non-recurrence, very few people put it in their top priorities. When I delved a little bit deeper with them on that, they would say that there are no assurances, that there cannot be assurances of non-recurrence unless Zionism is dismantled here. They did not think that this, they thought of it more also as a symbolic thing. Same thing with the commemoration of the Nakba here. So we're seeing that reparations for Palestinians come at a very concrete level, and that symbolic measures are not fulfilling Palestinian aspirations, or what at least Palestinians would find or would deem to be symbolic here. Because again, when we come to legal matters, we can interpret these to have legal, like an apology, to be beyond a symbolic thing. But the general Palestinian public did not see it as that.
Okay, unfortunately, I have to call time on this event with thanks to Law for Palestine, for the Gallatin Human Rights Initiative, for the organizers and the presenters, and the audience, remotely and in person. Thank you very much for your participation. To be continued.
Thank you, everyone. Bye-bye.
Thank you so much.
Famara, thank you. That was very informative.
That was really
Thank you. Thank you.
Yes.
Bye-bye.
Thank you, everybody.
so much.
Enjoy New York. Enjoy New York for me.
Hitler's a wonderful guy. He's actually incredible pain in the ass.
Yeah.
He's a wonderful guy. He's also incredible pain in the ass.
That's fine.
Well,
Yeah, no,
yeah, I agree.